You guys hear me? Give me a thumb, a heart, anything if you can hear me. Let's see if we can get a good turnout tonight, please. Awesome. Dakota, I've sent you an invite. Please accept that invite, brother. Okay, turn your video on there, brother, and you should be set. You're in.
Yeah, I'm here. Can you hear
Awesome.
me?
I can hear you. Can everybody else hear him?
All right. We're gonna get some good questions going on in here today. Today is towards answering questions that you may have. I know we all have questions here. So let's get the man to answer these questions.
So there's a little bit of background noise, guys. We've got a little bit of a festival going on this weekend. We've got the Million Mothers Prayer this weekend. So, man, God's got some good stuff going on. So we've got 1 million women coming into town. Probably not 1 million, but that's what they call it. It's coming in for prayer and for the preservation of the familial unit, which is, of course, exactly what I'm arguing and fighting for. So, man, it's going to be an exciting weekend. I already feel it. I feel the energy already. So, if you don't mind, let me just start with another introduction of what I'm doing. So, I'm Tanwood Downing. I'm a civil rights advocate and litigator. I am here advocating on behalf of people in the United States on a very, very significant case that will affect a great number of people across the United States of America. So, what I did was I've already served 33 state attorney generals. I've also served 33 state Supreme Courts on behalf of affected litigants within those particular states for a very, very specific crime. And that crime is that when a state chooses to enact its own alternative legislation and substitutes it for the provisions of guarantees of the Constitution, that would obviously be a very, very big problem because the only thing that makes America America is American laws. So failure to follow American laws results in a breakdown of our society. So Clause 1 of Amendment 5 to the United States Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. Now, an infamous crime is defined as any crime punishable by more than 1 year imprisonment in a penitentiary. Right. So, and the United States Supreme Court stated in the case United States versus Coachman that it's not the amount of time that you get sentenced to, but the amount of time you can be sentenced to. So most gross misdemeanors are also infamous because it's not the crime that determines the infamous nature of it. It is actually the amount of time that you can be sentenced to. So if you can get 3 years, but you only got 3 months, it is still an infamous crime. Therefore, it still requires an indictment by a grand jury. Now, we all know that Clause 1 of Amendment 5 is certainly part of the Constitution. It's part of the Bill of Rights. The Bill of Rights, the first 10 amendments. So because it's a part of the Constitution, then it's in effect against interference by anybody that's bound by oath or affirmation to support and defend the Constitution of the United States. So when a judge enters into his office, he swears a certain future outcome. He makes a promise to the people of the United States that he will fulfill certain things and produce a certain outcome. When he fails to fulfill that outcome, remember, he's already implicitly invited punishment in the form of perjury should he fail to fulfill such promise. So when a state, such as the state of Washington, enacted a provision in its inferior constitution, Article 1, Section 26, that stated that no grand jury shall be drawn or summoned in any county, then that means that the state of Washington has a provision in its inferior constitution that functions directly to the contrary of the United States Constitution, and now we have a supremacy issue. Now we got to get that part addressed. So what we're trying to do is we're trying to notify these states that they have illegal and unlawful acts that are being committed, because sedition is defined as the speaking or writing of words such as law established in order to cause disaffection to the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution, and to determine what that way is, we would go to Article 5, the special amending procedure, and that explains the exact way that you would alter, amend, or destroy any of the provisions and guarantees of the Constitution. Any other way would be an act of sedition done by traitors to the nation. So when a state commits that particular offense called oppression, where they create a law that affects one part of society unequally from another, then they direct their agents, being a prosecuting attorney, to charge by way of information, not by indictment, as required by the Constitution of the United States. That agent, the prosecuting attorney, has a duty and responsibility to ensure that the power that they exercise is consistent with their authority. If they choose to exercise their power based upon the abuse of delegated power by the state in this particular case, who enacted a law that's contrary to the Constitution, it's up to that public official to ensure that the power that they exercise is consistent with their promise, the oath that they made. So when that prosecuting attorney then chooses to rely upon the inferior state statute to deprive a person of the United States of the very rights that are guaranteed to them by the Constitution, that is a crime. It's called deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of the rights secured by the Constitution, commits that crime. Now, when that prosecuting attorney brings the incorrect charging instrument to the judge and says to the judge, I would like you to hold this person over, that judge has a duty and responsibility to ensure that the power he exercises is also consistent with his authority. If he chooses to exercise power based upon someone else's abuse of power, in this case the prosecuting attorney, then the power he exercises is no power at all, because he is relying upon someone else's criminal acts to take action, which means that he is now involved in and established a conspiracy to deprive of rights, Title 18, subsection 241. Which states, when two or more persons conspire for the purpose of depriving any person of any rights secured by the Constitution, commits that crime. So now we have a conspiracy that's been established by and between the judicial officer and the prosecuting attorney. And when that judge then signs that order, ordering someone to be held over for the offense, and then hands it off to an officer to go out and perform that arrest, that officer also has the duty and responsibility to ensure that the power he exercises is consistent with his authority. If that officer goes out and performs an arrest based upon the judge's abuse of discretion and the prosecutor's abuse of discretion, then he himself is involved in that criminal conspiracy. And now we also have the crime of kidnapping that has occurred, which is Title 18, subsection 1201, and it is a federal offense because the victim is being held over for ransom in the form of bail. And this is happening in every single state. This has happened millions and millions of times. And now we need to bring this to the attention of these public officials and say, hey, you guys are committing treasonous acts because you made a promise and you're failing to fulfill that promise. And when you do that, by your criminal acts, everything you produce is going to be unlawful, because only right can produce right, wrong will always produce wrong. So there's a maximum law that says that any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So when government chooses to act unconstitutionally, to perform an arrest because they did not have the proper documentation in place to do so, then by that unconstitutional act performing the arrest, that arrest is unconstitutional, which means that everything that derives from that unconstitutional arrest must also be unconstitutional because it is tainted by the illegality of the way it is obtained. So today, there are more than 700,000 people across America that are currently imprisoned illegally and unlawfully on direct constitutional violations that are facially written within the Constitution of the United States. They're being held in these institutions that we call sweatshops in China, but prisons here in America. We need to get those brothers and sisters the help that they need, the love that they need, so that they can heal from the traumatic experience. We need America to get out of the goddamn slavery institution once and for all. If anybody has a problem with me saying that, well, I'm sorry. I'm a little bit upset with this system. So Dakota is with Mind Evolution, everybody. He's my brother up in New Hampshire, and Dakota's going to be moderating this. So Dakota, he'll be answering these questions. He'll be directing them to me. I can't see. I just took the glass off, so I definitely can't see now. But try to keep your questions as general as possible. We'll stay here as long as we can, as long as the police allow us, and as long as the sunlight permits. So Dakota, please take it away, sir.
Okay. So everyone, I'm going to be looking out for your questions. You can ask your questions. Even if you want to, come up and ask your question and speak to Mr. Downing directly, we can get you up here and you can ask your questions and you'll be able to get answers that you're looking for. What you're going through and what you have been going through, I'm sure he has an answer for you. So if you have a question, feel free to come on up or ask your question. If you ask a question in the comments, I'll see your question and I'll ask it. How do we challenge court jurisdiction arraignments for misdemeanor charges? Says Wolf to Tenawa.
Okay, so with a misdemeanor charge, you have to look at whether or not it's infamous first off, right? So I said in the introduction there, what is an infamous crime? An infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. It's not the amount of time you get sentenced to, but the amount of time you can be sentenced to, which creates the infamous nature. Therefore, it's not the crime that drives the infamous nature. It's actually the duration in which you can be punished. Okay, so misdemeanors, unfortunately, are not infamous crimes. So if it's only up to a year, then that would not be infamous. There's other ways that we can address it, but Title 18, subsection 555 says that information can only be used for non-infamous crimes, for misdemeanors. So the law does permit information to be the accusing mechanism for that. But the problem is that, and this gets into something a little bit different, but so 98% of all convictions here in America come by way of plea bargain, right? That's 98% of all criminal defendants that don't even get to tell their side of the story, and that is an egregious failure of the justice system, okay? Truth will always lie somewhere between two stories. But when you suppress or prevent one side from telling theirs because you've chosen to accept someone else's side of the story, and as a result, you've taken a side against another individual, then what happens is that when you charge by way of information, then they use that information as a mechanism to be able to create pressure, right? Pressure against you. And through that pressure, they use duress, coercion, intimidation, threats in order to get you to plead guilty. Now, plea bargains aren't constitutional. They are absolutely unconstitutional. They're one of the things that we're going to be getting addressed here in the coming weeks here. But plea bargains aren't constitutional. Article 3, Section 2 clearly states that the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Nowhere in that does it say anything about adjudicating a crime in any manner other than a trial by jury. So when a prosecutor comes up to you and says, or through a defense attorney, because remember, witness intimidation tampering is not direct intimidation, it is also indirect. So when a prosecutor goes to your defense attorney and says, oh, tell your client that if they don't plead guilty, I'm going to send them to prison for 2 years, right? Or if you don't tell your client that if they don't plead guilty, I'm going to give them this heavy fine, or I'm going to take their children away. Each one of these things is a threat, right? And a threat is the establishment of the contract through illegal means. It's an act of extortion. Now, where the constitutional mechanism comes into play for this particular offense is the Fifth Amendment's self-incrimination clause. Because the self-incrimination clause says no person shall be compelled in any criminal case to act as a witness against himself. So compelled in this context means to bring about through the use of threats or intimidation. So when government uses threats or intimidation in order to get you to act as a witness against yourself, they have clearly, simply violated the Fifth Amendment self-incrimination clause. Well, the problem is that in a plea bargain, down at the bottom of that plea bargain, it says I did certain things and you sign it. which means that you are acting as a witness against yourself. And the way that they get you to do it is through the use of threats or intimidation. That means that it doesn't matter because the Constitution states that no person shall be compelled in any criminal case. So it's not just infamous crimes. It's also misdemeanors. So if you have been threatened or intimidated into pleading guilty, then guess what? That would be an unconstitutional act because the state has used threats, intimidation, coercion, or duress in order to formulate that contract. And we all know that duress is a justifiable defense for a crime, a breach of contract, or a tort. You cannot use duress to formulate a contract without formulating an unconstitutional, illegal, unlawful contract. So that's the first thing, right? So the contract itself is fully breachable because it's not valid because the way in which that contract was formed is illegal. Therefore, the contract formed is then illegal. It becomes non-binding on parties involved in dispute. But again, going back to what I said before, that any time that there's an unlawful act that's committed in the pursuance of an outcome, that outcome has got to be unlawful, right? Because you can never break the law in order to enforce the law. So when the crime of extortion is committed in order to secure that contract by that criminal act, nothing is valid at all, nothing. And so, when we look at the crime, the threat itself, who gets to decide whether or not you've been threatened or intimidated, right? Well, it's not the judge that gets to make that determination. You are the one. And the reason why is because intimidation is an inward manifestation. It's not an outward manifestation. So the judge can't say, well, show me your intimidation, like it's a scratch on my arm, right? So you get to make that decision. You decide if you've been threatened or intimidated, you know that, and only you can know that. Nobody can tell you that you weren't threatened or intimidated, right? It's not up to anyone else to make that decision. It's up to you because it's an inward manifestation, not an outward manifestation. So the moment that they use threats or intimidation in order to get you to plead guilty, that would be unconstitutional. It would be illegal. 1 second, guys. Just 1 second, guys. I'll get the rest of you in here in a moment. I see that you guys. There's a couple others that want to come in. Just 1 second here. So now another thing that we need to consider here is, and I got to play this one out just a little bit, okay? So when a judge says to you, because most people would say, yeah, well, the judge asked me if I've been intimidated. I said, no, I haven't been intimidated. Well, that's not binding. And let me explain to you the reason why, okay? So the state is made up of a body of men, the whole body of men. And that body of men that makes up the state includes prosecutors, it includes judges, it includes attorneys and law enforcement. All of those agents make up the body of men that is the state, okay? So pretend that my body is the state of Washington, okay? My hand is the prosecutor and my shoulder is the judge. If my hand comes up to you and threatens you and tells you to plead guilty or else, and then my shoulder asks you if you've been threatened, look, my shoulder represents the very same body doing the threatening as the one asking you if you've been threatened, which makes the plea non-enforceable. If the state wanted to enforce a plea bargain by asking you if you've been threatened or intimidated, they would have to bring someone in from outside the body of men that makes up the state. Otherwise, the very same body of men that do the threatening cannot be the same body of men doing the asking whether or not you've been threatened. That would make that plea unenforceable because if one part of the state of Washington threatens you, all parts of the state of Washington threaten you. So if you did plead guilty, you are still in a non-binding agreement because that judge had no authority to be able to ask you if you've been threatened because he represents the very same body doing the threatening as asking you whether or not you've been threatened. Thank you for the question, brother. I hope that helped. Cody, you back on, brother? Yeah, thank you.
Yeah, I'm back on. So we had a gentleman by the name of Wolf. He asked, what if the name is in a trust and the DAs are creating the funds from the name that's in the trust?
Yeah, so the problem today, guys, is the fact that so most of these people don't understand the system that's in place. Most of them, they have no clue what's going on. They're absolutely brainless. These people that say that they know the law, right? They know less about the law than any one of you. These guys are scared to death. These attorneys are scared to death, right? They're scared to death of what's coming forward because they actually have no idea how to practice law or what law is. They're at a significant detriment because they've been led astray for far too long, and everything that they've learned has been unlawful because they're relying upon things that are not the law. They're relying upon things that were wrong and fraudulent and based upon false pretenses. And every single day, they're profiting off of their illegal acts, which means that they are actually committing treason. And I mean, it's insane, the situation that we're in and who we're relying upon. The very people we put into place to administer and enforce the laws are absolutely breaking them in order to profit off their illegal acts. So, um, when I went out and I served these 32 attorney generals and these 33 state Supreme Courts, when I went out and did that, I didn't do that because I expected that they were going to suddenly just say, oh, well, he's right. We're going to change. We're going to do things right. That was not what the intention was, right? Not at all. What I was doing was I was actually notifying all of them so that none of them can represent the people now. Because when I notify the highest executive officer within the state, who is the attorney general, right, who's in charge of every single attorney because he's the attorney general, right, the general in charge of it. So when I notified him, right, he then had a duty and responsibility to take action. When he failed to take action, then by his inaction, he has automatically implicated every single person that works for him, because notice to agent is notice to principal, but notice to principal is notice to agent. So I didn't have to go around and notify and provide notice to each one of the prosecutors and every one of the attorneys, when I could just go to their boss and say to their boss, here's the unlawful act, you're served now, what do you want to do about it? And by their failure to take action, now we have a massive number of people that are accused. We've got 33 states and 33 state courts that have no authority whatsoever to be able to adjudicate this situation, because none of the court officials have the authority to be able to represent the people, because they're all now opposing party. So when I went and I served the highest judicial officer within the state, being the Supreme Court, all right, now they've all been notified. By their failure to take action, now no judge in the state can oversee the disposition dispute, because their the highest judicial officer failed to take action and direct all of his agents to act in a lawful manner. So now we've got 33 states that have got automatic recusals. Every single public official in the state cannot take action on behalf of the people. And now the only court that can oversee this dispute is the court behind me, right? We're coming into a position where we are forcing them to have to take this case. Not asking, we're telling you, you must, because you are the court that has authority to do so. Now, again, going back to your question, I didn't expect to see, the relief for you guys. I didn't expect them to just wake up and say, okay, we're gonna do the right thing now. You're right, blah, blah. I expected great opposition, which we did have a ton of opposition, and we still do have opposition. But at the end of the day, the problem is that, we the people, if we are led by criminals, right? Because a criminal is defined as simply one that transgresses the law. If our country is being led by criminals, people are acting outside of the established code of conduct agreed upon by the majority, the Constitution of the United States, the very law that creates their office and grants them authority, then that means that our country is going to be led toward crime, which means that we're going to produce criminals as a result of it, right? Because if our leaders are criminals, then they're going to lead us toward criminality. So that's the people of the United States. We need to make sure that if we don't want to be criminals, then we can't follow criminals that are leading us. And every single day, every single public official is now a criminal. I've shown it. They're all acting in committing treason because they're failing to fulfill the obligations that they made, the promise they made to people of the United States. And they've already implicitly invited punishment in the form of perjury should they fail to fulfill it. And remember, perjury is a violation of public trust, meaning that you can't be trusted by the public to do the lawful thing, which means that you can no longer hold public office. You are immediately impeached, especially the judges, because Article 3 says the judges, both of the United States and of the several states, shall maintain their office while in good behavior, and good behavior is defined as the avoidance of criminal behavior. So as a judge, the moment that you engage in criminal behavior, and perjury is criminal behavior, the moment you engage in it, you are discharged according to the laws of the United States, the Constitution of the United States. If you choose if you choose to abuse the powers that you're given in order to offend the very object that afforded you your powers, you become an enemy of that object, and its wrath is unavoidable. If the Constitution provides you, judge, with your authority and your power, and you choose to breach that law in order to offend the very people that are there to be protected by the Constitution, then don't think it's going to protect you. Don't think you're going to get immunity, because that's just silly thinking, right? The document and laws that were created to protect the people cannot be breached and then find protection by that law. So just like the people are following our leaders who are criminals, the same can be said about these judges and everyone else. The reason why the judges are not acting lawfully, the reason why the prosecutors are not acting lawfully, is because their leadership is permitting them to do it. So as long as we have criminals behind us, right, that are choosing to not fulfill their obligations and the obligations that codified in the Constitution of the United States, the very document laws that were put into place, that their institution was created to protect and defend, and now they become willful accomplices in the destruction of that law, then we will not see lawful acts by their agents. As long as the leadership is committing criminal acts and not following the law, then all the agents are not going to follow the law as well. So that's why I'm fighting crime from the top down. I'm not fighting against these judges out here at the edge. I'm not fighting against the prosecutors. I'm simply notifying them of their crimes, but I'm notifying them of their crimes so that these group of 9 people behind me here, that they can understand the train wreck that's coming their way, and they can get their asses ready because we're coming after them. They can either act lawfully or they can answer the people of the United States, and we know how that's going to go. Because when you choose to accept an oath and an obligation, when you refuse to enforce the body of laws govern this nation after taking an oath and a promise to do so, that is an act of treason. It's an act of treason. And so we now have 9 justices here in Washington, D.C., that work for an institution that has never, since the history of the institution, since its establishment in 1791, has never, ever, ever recognized or enforced the body of laws governing this nation. And so we now need to bring it to their attention and say, what do you guys want to do? You 9 men. You can act honorably and thus maintain honor of your institution, or you can act dishonorably. And we're going to make sure that everybody in the entire nation knows just how much criminals you and your predecessors actually are. So, the answer is that, what's happening to you is not lawful. It's not, right? The prosecutor coming after you, it's not lawful. But they don't understand the laws because their leadership is permitting them to not know the laws, right? If we can get these 9 men right here, if we can get them to change and get them to self-reflect on their actions and their institution and the unlawfulness of, and the fact that they themselves, this is the reason why our country is getting destroyed today. These 9 men right here are the reason why America is fracturing, breaking apart. This is the source of all chaos and all crime. This institution behind us right here. If we can get them to self-reflect and say, you know what, I don't want to be a traitor. You know what? I don't want to be the reason why America is destroyed. If we can get them to accept their criminality and choose to do things lawfully, then by their turn toward lawfulness, we will get all of their agents to immediately turn toward lawfulness as well. So that's why we've got to start at the top and work our way down. We're not going to get all the agents to obey the law until we get their master to obey the law. Thank you.
Gentlemen, let me ask you a question. This is great information sharing, right, brother?
Yeah.
But I'm sure that the people want to get a more direct answer if you're going to be answering questions, right? So it was great information that you shared, but I'm not sure if the question really got answered. So let me ask you a different way, right? So if you have a trust, right, and they access, and create bonds from your trust, what kind of action can you actually take to prevent them from accessing your trust? Because from my perspective, I know that there have to be an express written consent. And if there's no express written consent, then they have no authority to access or create any bonds or attach your name to it. That becomes identity theft. So what kind of action steps?
Except for the fact that most people are in a minor status because of the contracts that they've entered into with the state. So this is where pro se versus sui juris comes into play. When you're pro se, you have contracts with the state, which is a minor status. Pro se means that you're a minor, you're under the control of someone else. So I've had this conversation with a couple institutions, including Society First, and we're looking at options at how can we shift this trust over from control today under the Attorney General, right? When we don't want him to have control of our trust anymore, how can we create a new trust with a new fiduciary and shift everything over? Because the reason why people go to prison, right? The reason why people go to prison is because while you're in prison, your trust is just building interest. It's building interest. And guess who gets that interest? Nobody can touch the trust money, right, once you die, right? But they can get the interest. Every single cent that's paid in interest goes to the Bar Association. It goes to them. So, every day that you're in prison, your trust is building interest based upon the value that's contained within it. And so if you're not able to purchase a car or purchase a house or open up any of these other credit lines, when you're unable to do that, then your interest is just building and it's building. and that interest can then be taken off the moment you die. That's why these courts love to give life without parole, because they know that the moment you got life without parole, you can never ever access your trust ever again, right? You'll never ever go out and use the money that you have, and therefore that interest is just gonna build. That's the philosophy behind it, that the moment you're born, between birth and 18, your trust is just building. It's just building in value. And so all that interest is just accruing. But then when you draw out of it is when you go and you buy a house, or you go and you buy a car, or you go and, that's where the money is created, and it goes to your QSIP and through this SQV account in the Treasury, and then you draw the money out. And so now, the Bar Association is losing money for every time you go and buy a car, every time you go and buy a house, and they don't want that. They want to freeze up that money so that they can build that interest, because that money goes to them. So, yeah, you're absolutely right. But what we have to do is, just as I was saying with Society First the other day, the first thing we have to do is we have to find a way to become men once again, right? Not a minor. We have to overcome the minorship, and that's what I'm trying to do here. Like once we show that the state's laws were all unlawfully created because they relied upon judge-made rulings, that was called a law, right? Case law. But judges can't create law because that's a separation of powers issue. So the moment that a judge created a ruling, and then the state relied upon that ruling that was not law to create their law, well, that's unconstitutional. It makes the judge-made ruling a law because they called case law, and judges can't create law. And then the state relied upon, stare decisis and judges' rulings and opinions in order to formulate and create their law. And now what we can do is we can go through and we can destroy all of these state laws, destroy them. They're done, because they all rely upon, just as Justice Gorsuch is saying right now in his book and in his campaign around the country, all the news that's talking about it, the states are relying upon, or the courts are relying upon, administrative law and not common law, because judges do not create law. They create rulings, but when they call it law, then that means that the state relies upon that judge-made ruling to create a statute. That statute is unconstitutional because it relied upon something that was not constitutional to begin with. Judges don't create law, they create rulings. So when a judge creates law or a ruling and calls it law, that would be an unconstitutional law. And any state that relied upon that unconstitutional law to create their law means that their law itself is unconstitutional because it's progeny to an unconstitutional act, right? So we can go through now and we can destroy in a massive swath, we can destroy a massive number of state laws, which are where the contracts were created for all of you. Your driver's license, your trust, the house, the taxes, all of these things that we're fighting, we can destroy in one massive swath right now, get us down to a foundational level to where you're all free of the contracts that they say you voluntarily entered into, which I would agree that you guys didn't voluntarily enter into anything because you didn't understand, right? But nonetheless, they say that you have to obey the driving laws because you entered into a contract with the state when you went out and got a driver's license. Now you're subject to state driving laws. You weren't subject to them before until you entered into that contract and agreed to get the driver's license, right? So we can destroy all of this from a number of different things. First off, bankrupt this corporation. We're already in bankruptcy today. 1933, we went into bankruptcy, finalized the bankruptcy. That's what I'm saying that we need to do, because if we finalize this bankruptcy, first off, all debt, public and private, is to be paid by the Treasury, right? That's HJR 192, House Joint Resolution 192 says that all debt, public and private, must be paid by the Treasury. But people don't own the Treasury. So the $34 trillion that we believe we owe as a national debt, that's not our debt. That's the fiduciary, that's the Treasury's debt. They accepted the risk when they put us into bankruptcy, put themselves into a position. And so to deal with the trust, the first thing we have to do is we've got to get ourselves out of the minor status. And that's the work that I'm trying to do, Dakota. I'm trying to get us out of the minor status by destroying everything that created those contracts. The state laws were not valid. They were created unlawfully based upon the reliance of something that was not law. And when that happened, we foolishly or erroneously entered into contracts. They are void contracts. You're absolutely right. But the easiest way to void the contract is by avoiding the device that created the contract. So if the law created by the state didn't have authority because it was created by something that was not constitutional or lawful. I'm sorry, guys, I got mosquitoes all over the place here. So if the state statute relied upon something that was not constitutional to create the law, then when you entered into a contract to be bound by the law, then if we void the law, that voids the contract. And so now we can get you all free. And the moment you're free, we can move that trust from the Attorney General, move it into something else, something that's going to work, get your money to you, and not have it under the authority of the government. That's your money, not the government's money. It's your money. So I hope that helps, brother.
Okay. So let me ask you this: in a pro se situation, right? Let's say someone removes their case and takes it to a higher court, but the higher court says, well, you have to come under pro se, judging from what you just said, we don't really want to be underneath pro se because that creates a contract. So how do we exit that contract?
So the contracts exist in many different forms. Okay, let's say that you're in the court for a driving incident. So what happened there was that you entered into a contract with the state when you chose to go and get a driver's license. Now, whether or not you understood that you didn't have to have a driver's license because government cannot interfere with your use of your private property. Your vehicle is your property. That's your private property. It's yours, right? And because it's yours, government cannot interfere with your use of that private property unless you enter into a contract, changing your legal relationship with the state, permitting yourself to be subject to it. And that's what they claim. They claim that you willfully entered into a contract to obey the state driving laws. But government cannot interfere with your use of private property. So that vehicle is yours. You could do with it what you want as long as you're not harming someone else, right? And so But when you enter into a contract with the state to get a driver's license, now the terms are important because now you're not traveling, now you're driving. Now you've entered into a contract that agrees to obey the driving laws, right? And as a result, now you are subject to criminal or civil sanctions should you breach the contract terms that are in place. So, if the contract says I will obey the driving laws and the driving laws say you have to drive 60 miles an hour and you're out driving 75 miles an hour, then they could pull you over because that's a breach of contract. And as a result of the breach of contract, now you need to come into a courtroom to negotiate the terms of the breach, right? But where they get you on the second one is your vehicle, your private property. When you take your private property and you register it with the corporation, guess what? Now you're driving for commercial purposes because now that vehicle is a commercial operating vehicle, right? So when the Supreme Court comes out and says that you can travel for non-commercial purposes freely without a license, when they say that, well, what they're saying is that you willfully entered into a contract to subject yourself to the driving laws, and then you've taken your vehicle and you've registered it with the corporation, and now as a result of registering it with the corporation, now you are operating for commercial purposes, and now that's not your property, it's registered with the corporation. That's where they get you. Now, the other way that they get you is if you purchase a vehicle, right, and that vehicle is financed. Well, you enter into a contract with that finance corporation, and in that contract, it says, I'll have a driver's license, I'll have insurance, I will register my vehicle, and now you are bound to certain obligations because of that particular contract. If you want to avoid the contract, you cannot enter into a contract with a finance company because obviously the finance company wants to proliferate this whole concept because this is all about the banking institution. So when you agree to finance a vehicle because you don't have the money to be able to pay for it, and you agree that you're going to go to this bank and ask this bank to go to your SESQV and pull from your QSIP from your own account, and then they give you the money so that you will sign an agreement to get a driver's license, get your registration, carry insurance. Those things you don't have to have unless you're in a contract with them agreeing to do it. So this whole system has been set up to confuse you into not realizing that vehicle is your property. You paid for it with your money out of your account, and you went to someone else and agreed to certain terms that you're now bound to follow as a result of nothing more than them wanting to proliferate this ignorance that exists. So what happens then is that in order to not be subject to those particular laws, two things has to happen. First off, you have to remove the contracts, which means that vehicle can't be registered. You remove it from the corporation. That's my vehicle. I own it. You, corporation, have nothing to do with this. Now it's my personal property. I can do what I want with my personal property. Government can't interfere with my use of it. And then you must remove your driving status, right? I'm not a driver. I don't have to have a license. I'm not going to have an agreement with you, state, because I have the freedom to be able to to operate this private property in whatever way I see fit. I will choose to be obedient to your laws out of love, faith, and obedience to my fellow man, meaning that I'm not going to drive in a reckless manner. I'm going to drive consistent with your laws because that's what my fellow man has said that he would like me to do, and I'm going to willfully subject myself to it, but I'm not going to be subjected to it under contract. And that's a very, very important point. Now, the second thing is that in order for this to work, right, we need those that are in a position of authority to understand that they're exceeding their authority when they breach the obligation. They believe that they can do these things because that's how it's been done for 100 years. And it doesn't matter how long it's been done or how many times it's been done. Wrong is always wrong. And if you're doing things wrong, prosecutor, you're doing things wrong, judge, then it's still wrong and it can never become right. So we need something that's going to wake them up to a massive scale. But you guys got to get out of your contracts, and that's what I'm trying to do here. Is we can void these contracts by voiding the state laws, and that's what I'm doing here at the Supreme Court. We're extremely close to it. I'm using one specific mechanism, the indictment by the grand jury and the breach of obligation as a result of the failure to use the indictment by a grand jury by these 32 states. But that simply is the bigger introduction to show that these states and statutes, they have no authority because just as Justice Gorsuch says, they're based upon administrative law, not common law. They have no validity whatsoever. Courts can't rely upon something that is not common law. They can't become willful accomplices in the breach of the very laws that they were instituted to be able to protect and defend.
Wow, that's very powerful. And you know what? I like to add too, man, to everyone who is listening, you might want to look at that registration, right? Because they always say you got to read the fine print. Well, on that registration, there is a fine print that says specifically for commercial motor carrier use only. And it's on the actual registration in your car. That's what puts your vehicle in that commercial capacity. So it's important for you to understand that and just go read it. Read your registration. I guarantee you'll see it. So the next question.
Well, there's one thing I want to add to that, if I could. So the Supreme Court's theory behind the Thompson versus Smith ruling, where they said that you don't have to have that you can travel for non-commercial purposes. This is the rationale behind it. Okay, so if each state has their own independent driving laws, right, and driving statutes, right, and you go and you apply to the corporation for a driver's license in the state of, say, Montana, right, now you're subject to Montana state driving laws, but that means that you can travel through the state of Pennsylvania, not obeying the Pennsylvania state driving laws, and guess what? They can't enforce the state of Pennsylvania. So if your driver's license is suspended, for instance, out of Montana, and you're driving through Pennsylvania can't do anything about it. You can travel through the state of Pennsylvania because you're not subject to Pennsylvania laws, and the state of Pennsylvania cannot enforce the laws of Montana, right? So you have the authority to be able to travel for non-commercial purposes. Now, the non-commercial element is that when you have a CDL, the CDL is enforceable across jurisdictional lines. So if you have a CDL, then that would be subject to enforceability within each one of the independent 50 regional governments. But if you have a independent driver's license that's suspended, or a registration suspended, or even if you don't have your vehicle registered and there's no tags on it, you can drive through a state, because I don't have to go and get a driver's license in the state of Pennsylvania simply to drive through it, right? And if I'm not there for an extended period of time, more than 60 days, I don't have to have a driver's license. Therefore, I can travel through the state of Pennsylvania without a license, with it suspended, with or without tags. It doesn't matter, because the state of Pennsylvania cannot enforce the different states' laws. So that's the rationale behind the ruling from the Supreme Court. That's one of the reasons why I don't spend more than 30 days in any particular area. I'm constantly on the move because I have to maintain my particular status. I don't have an ID. I won't get an ID. I will not accept a state ID. The only ID I carry is my veteran's ID, which is a federally issued ID, and it's good for travel. And so as a result, I could travel through the states, and the states have no authority to be able to enforce another state's laws. We know that. Jurisdictionally, the state of Pennsylvania cannot enforce the state of Montana's laws. So if the state of Montana says that I don't have a driver's license, state of Pennsylvania, you can't do a goddamn thing about that, period. Okay?
That's powerful. All right. So the next question comes from Cindy, right? Cindy asks, what happens if you're arrested under false allegations and a retracted story in a police report?
So we talked about this the other day, Dakota, right? We talked about it the other day. So what they try to do with you guys is they are trying to create a conflict, right? Because without a dispute, without a conflict, there is nothing to judge. Because all that a judge is simply an arbitrator of a conflict that exists. That's all he is. So if there's two parties that are coming together in conflict, one saying that this person didn't do something, didn't fulfill an obligation, this one saying I did fulfill the obligation, now you need arbitration to be able to determine an outcome, right? So what they're trying to do is they're trying to create a conflict with you, okay? What I'm trying to do is I'm trying to draw everybody back. So when you look at sports, for instance, the best position to be on is not defense because the other team is going to score. The best position is on offense because that means you're going to score, right? So what we have to do, what you need to do, sister, you need to stop defending yourself, right? Don't worry about the thing. All the things that you just mentioned are all distractions. They're trying to distract you to create a conflict to get you to actually do what they want. They want to create a conflict so that you will defend yourself. And that's what you're doing right now. You're defending yourself by saying, oh, they retracted the story. Oh, they did this. And they said, don't worry about any of that. You now need to go on offense. And you go on offense by accusing them of a crime. Because if government commits a crime in the pursuance of any outcome, that outcome is going to be unlawful, it's going to be unconstitutional, and it's not valid, period. So you go on offense. Stop defending yourself. Don't worry about the things they said. At some point in time, that will be significant when it comes to injunctive relief. But initially, to overcome the government and the oppressive acts that they're committing against you, you go on offense. You figure out where they committed a crime against you, and I'll tell you exactly where. It's jurisdiction. The state has no authority to be able to oversee that dispute. Because when the officer brings an accusation against you, such as the case that you have, the officer represents the state. When the state becomes the accusing party, then the state itself cannot be the judge in the party. And as a result, the judge has a constitutional obligation to recuse himself because he has a conflict of interest. He works for the plaintiff, as does the officer, as does the prosecutor, as does CPS. They all work for the state. The state cannot be both accuser and judge in the same party because that would be a conflict of interest. So Article 3, Section 2 of the United States Constitution says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So when a state or the body of men that make up the state, if any agent or any member of that body of men bring an accusation against you, that judge has a constitutional obligation, codified in Article 3, to recuse himself because he has a conflict of interest. He works for the plaintiff. That is a crime. And the moment that crime is committed, everything that the state produces from that moment forward is unlawful. It is unconstitutional. It is fully void without force or effect to the parties involved in dispute, because any time that a court acts without jurisdiction, what it renders is void, non-binding, refer to Civil Rule 60b-4. Okay, so in order for a court to render a legally binding decision, it must have two things. It must have subject matter jurisdiction, and it must have personal jurisdiction. Subject matter jurisdiction is the right to oversee the type of case that's brought before it. So in the case of a death, for instance, you wouldn't bring that to a small claims court because they wouldn't have subject matter jurisdiction to oversee the disposition of the deceased assets. You would bring that to a probate court. The probate court would be the court that would have subject matter jurisdiction to oversee the disposition of the deceased assets. Now, the second thing that they must have is they must have personal jurisdiction. Personal jurisdiction is the right to oversee the parties involved in a dispute. So when Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, what that says is that if a state is a party in a cause, then personal jurisdiction, because the authority to oversee the parties involved in dispute, is constitutionally assigned to the United States Supreme Court. No other court in the country has personal jurisdiction to oversee the parties in dispute if a state is named a party. So by that breach of constitutional obligation, by that jurisdictional breach, that creates a jurisdictional error. And through that jurisdictional error, now whatever that court produces is unconstitutional. Refer to Civil Rule 60b-4. 60b-4 says that a judgment is either valid or void. It's valid in all instances except for when the court rendering a decision lacks either subject matter jurisdiction or personal jurisdiction. If the court lacks either one of those two things, what it produces is unconstitutional and void. And a void judgment is always in forever void. It can never become valid because the court can never obtain jurisdiction when it lacks jurisdiction. In fact, the United States Supreme Court behind me here in January, they made a ruling that stated that the difference between a claims processing rule, which would be an appeal, and a jurisdictional rule is that a jurisdictional rule can never be waived. It can never be forfeited because jurisdictional rules derive from statute. It is a first duty of the court. Before that court can even call anybody in, it must determine whether or not it has jurisdiction. And if it exceeds the jurisdiction that it has, what it produces is void because it had no authority to be able to even take action in the case. So your case is void. What they're doing to you is unconstitutional. Don't fall into the trap of allowing them to create a conflict. Step back from the conflict and don't engage them in the arguments that they're presenting to you because they're trying to create a dispute. Say there is no dispute because you, court, had no authority to bring me in. You, judge, have no authority to oversee this because you, judge, have a constitutional obligation codified in Article 3 to recuse yourself. And if you don't, then I'm sorry to tell you, but Hill versus the United States says that anytime a judge acts without jurisdiction, he's warned against the Constitution and committed the crime of treason. And that's a very, very serious punishment. So step back, go on offense. Don't defend yourself anymore. You have nothing to defend. Go after them. Point out the crimes that they committed and don't talk about anything after that. Thank you.
All right, all right. So we have another question. Thank you for that answer, Tedawa.
Thank you, guys. Thank you.
We have another question from Hale. Said, what if a attorney is acting as a broker or accountant under my name and information to launder?
He's committing fraud. Yeah. So you know what happens is that what happens when you give a power of attorney, for instance, right? And you grant someone power of attorney, you're granting them permission to be able to, to control your accounts, to take care of you, all these things. Power of attorney is simply an attorney. So you're giving them permission to be able to oversee the health and welfare of your needs. You're actually placing yourself into a minor position by doing that. Attorneys want to be in that position because they believe that they can do those things. Because once you are placing them as an attorney, you're placing yourself in a subjection to them, and you're permitting them to do all kinds of things to them that is absolutely not in your best interest, but in their best interest. That's why these attorneys are driving around in Rolls Royces, and and that's why these attorneys are charging you $20,000 so you can still go to prison on a plea bargain, because this is the only career that you don't have to do anything. There's no performance criteria, right? They can do whatever they want and charge you whatever they want. And guess what? We don't know any better. It's not all right. And so, no, what they did was a crime. But once again, you have to separate yourself from the minor status that you permitted yourself to be in. Because when you permit someone to have a power of attorney over you, right? Then by permitting them to have a power of attorney over you, you're permitting them to act in your interests. And so, remove that contract, get that asshole the hell out of there, and go after him for the fraudulent acts that he's committed. That's not in your best interest, because of course, if you're not acting within the best interest of the person that you have power of attorney over, then that would be a fraudulent act. So, it's very obvious if they are stealing from your account, stealing from your trust in order to enrich themselves, that would be fraud. Plain and simple. So, but you need to first remove the minorship status that you have through the power of attorney. Get that removed, and once you do, go after him for the crimes he's committed against you. Yeah, get your money back, brother.
There you go. There you go. Thank you. Thank you for that answer. Thank you for the question, brother. We have another question from Griselli's. She asks, what are the first steps you make when your children have been removed by DCYF and legal standards not met?
Okay, so let's take a step back once again, because once again, we don't want to defend anymore. Sister, there's nothing to defend. The question I have to you is, did the state have the authority to take your children? Did they have the authority to take your children? The answer is no, absolutely not. Without a doubt, period. Let me explain to you the reason why here, okay? So the Constitution of the United States is the supreme law of the land. It provides the requirements that every single state must follow, because the only thing that makes America America is American laws. The only thing that connects California to Maine is the Constitution of the United States. Without it, there is no nation, there is no union, because the only thing that creates a union is the Constitution of the United States. So when the United States Supreme Court comes out in 1984 in a case called Roberts versus United States and state that you have the right to intimate association, meaning you have the right to have an intimate familial relationship with your child without governmental interference, and your child has the right to have an intimate familial relationship with you without governmental interference, then that means that no government can interfere with your relationship with your child, because if they do, that would be a violation of the Constitution of the United States, right? So, Dakota and I, we talked about this the other day, because he was pointing out the fact that a prosecutor in New Hampshire was stating that the New Hampshire Constitution permits them to do this. And I pointed out the fact that, yeah, but the United States Constitution doesn't permit them to do it. And so therein lies the confusion that you guys often find yourselves under, is that when a state enacts its own alternative legislation that diminishes, deprives, or abridges the guarantees of the Constitution of the United States, that is unconstitutional. So if the Constitution of the United States preserves your right to have an intimate familial relationship with your child without governmental interference, found to exist under the First Amendment, because remember, the First Amendment is extremely important. The First Amendment are all the God-given rights. Everything after that is not God-given, right? Because the First Amendment are freedoms, everything else is rights. So you have the freedom to speak, you have the freedom of religion, you have the freedom of press, those are freedoms because God will permit you to speak until the day you go home. It can never be taken. Therefore, you have a freedom to speak. Now, the right to bear arms under the Second Amendment is a right. It says you have the right to bear arms. Well, it's a right because God didn't create the gun. What God did do is he gave you the freedom to defend yourself, absolutely. But the way in which you choose to defend yourself is a right that's preserved under the civil rights and the notions of our society. So everything after that is not God-given, but the First Amendment is. And the reason why the Supreme Court made the decision in the Roberts versus United States case that it's protected by the First Amendment is because God made you a mother. God made you a father. Only God can take that away, because until the day you die, you will remain a father or a mother. Therefore, it must be preserved by the First Amendment, because it's not something that man creates. It's not something the state creates. It's something God created. So therefore, no state can take it away, because nobody can take from you something that God gave to you. Never. You will remain a mother or father until the day you die. Now, so I think we got the point across there, that the Constitution of the United States protects your relationship with your child, protected under the First Amendment. Nobody can take it away. So when a state enacts an inferior statute in its provision, in its Constitution, that permits the judges or prosecutors or DCF to take away your right to have a relationship with your child, that would clearly be an unconstitutional act, because it violates the rights that are guaranteed by the Constitution of the United States of America. So now we have the issue that I started out talking about in the beginning, that anytime a state creates a law that takes away any of the guarantees of the Constitution of the United States, that would be an unconstitutional law. And by the creation of an unconstitutional law, when they direct their agents, being a judge, a prosecutor, DCF, it doesn't matter, when they direct their agents to rely upon an inferior state statute that permits them to breach the obligations that they have of preserving your right to an intimate familial relationship with your child, when they do that, that is a crime. Deprivation of rights under color of law. And when two or more people do it, now it's conspiracy to deprive of rights. It's also perjury. It's also oppression. It's also extortion. There's all kinds of crimes that exist as a result of what they did to you unlawfully, unconstitutionally. So now here, so the Supreme Court came out, 1984, Roberts versus United States, and they said that you have the right to an intimate association with your child without governmental interference. Your child has the right to an intimate association with you without governmental interference. Okay? So they said that it was found to be a fundamental constitutional right. The First Amendment are all fundamental. Everything within the First Amendment are fundamental constitutional rights. And that's very, very important, right? Because a fundamental constitutional right is the most important civil right that there is. It's the highest, the most important, because that is essential to the structure and fabric of our society, that it must be fundamental. All the First Amendment rights are fundamental. Speech, religion, press, relationship with your children, family unit, that's all fundamental. Now, when you deal with a fundamental constitutional right, there's only one way that it can be taken away, and that is called strict scrutiny, and it requires the compelling state interest test. Now, with the compelling state interest test, basically what has to happen is that the state has to show that there's absolutely nothing else that they can do but deprive you of that right that's guaranteed by the First Amendment. And 99% of the time, when when the deprivation is measured or compared against strict scrutiny, it's determined the state has exceeded the power authority statutorily conferred upon it by the Constitution in their act of deprivation. So the moment they took your child without relying upon the judicial test of strict scrutiny, that was illegal. So there's 4 levels of judicial tests, 4 of them. The highest is strict scrutiny, requires the compelling state interest test. Now, again, the compelling state interest test is that the state must prove that there's nothing else they can do but deprive you of this right. Now, by making that statement, listen to what I just said. They must prove that there's nothing else the state can do, which means that no state court can remove a fundamental right because the state has to prove to someone else that there's nothing else that they can do, which is why only a court of federal jurisdiction can take away a federal right. If a state could take away a federal right, then that would mean that state is more powerful than the federal government because the federal constitution resides outside of the limited or statutory governing limits of a state. So a state cannot act outside of its limited statutory governing limits to abridge the federal constitution, right? Every day they say, oh, that's a state issue. Go argue with the state. It's not a federal issue. Awesome. Well, if it's not a state issue, how can the state abridge a federal issue? So if it's a state adjudication, it has no authority whatsoever to take away a federal constitutional right because that's a federal issue, not a state issue. So the state must prove to the federal court that they have nothing else that they can do. And when they do that, they fail. So there's 4 levels of judicial test. The highest is strict scrutiny, requiring the compelling state interest test. State didn't do it in your case. The state did not go to the federal court and say to the federal court, I want to take away this federal right that's guaranteed by the federal constitution under our state authority. Can't do it. They didn't do it. But the lowest judicial test is what's known as the discretionary test. I mean, the judge can use his discretion to take away a constitutional right. Discretion may not ever, ever, ever be used with regard to a fundamental constitutional right. Never. So the judge, he used his discretion abusively by using the incorrect judicial test to remove something that he had no authority to remove because he relied upon an inferior state statute that said he could do it unlawfully. So now we have an abuse of discretion. That judge has abused the discretionary authority with which he's invested in law by using his discretion to take away something he has no authority to take away. So to determine abuse of discretion, we want to go to the Circuit Court Handbook, United States Circuit Court Handbook. And in the Circuit Court Handbook, it says that there is a 2-part test to determine abuse of discretion. Okay, 2-part test to determine whether or not abuse of discretion has occurred. The first part is hang on, guys. I got to do this puzzle connection here. So there's a 2-part test to determine abuse of discretion. The first part is, did the judge rendering the decision, did he use the incorrect test? The answer is yes, absolutely he did. I just showed you that the judge was supposed to use the highest judicial test, which is the compelling state interest test, and instead he used the lowest judicial test, the discretionary test, and as a result, yeah, an abuse of discretion did occur. Now the second part of the test is any erroneous view of the law is an automatic abuse of discretion. Any erroneous view of the law is an automatic abuse of discretion. Now, let me tell you what an erroneous view of the law is. That in the judge's legal contemplation, that the lowest form of law, being a state statute, is in legal contemplation superior to the highest form of law, the Constitution of the United States. That would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion did in fact occur. Now, according to Blackstone, anytime that there's an abuse of discretionary authority by any person invested by law, anytime that there's an abuse of discretion, that there's 3 crimes that occur automatically. It's the crime of extortion because they are compelling a result through illegal means, right? They're compelling a result through illegal means. They are bringing about a result through an abuse of their discretion, okay? That's the first crime. The second crime is perjury because they made a promise they'd do something and they didn't do it. And as a result, they've already implicitly invited punishment should they fail to fulfill that promise. The third crime is oppression because what they're doing is they are applying the law unequally amongst different parts of society. That judge made the decision that same day that he's going to permit this person to have their kids, but not you. And that means that the law is being applied unequally by a person in position of authority, which is a crime of oppression and tyranny. So the answer is, sister, they didn't have authority to be able to take your kids. They didn't have authority to do it. And you're exactly the people that I'm fighting for. We are going to get these kids home to their families. We're going to get them the love and support they need so that they can heal from the traumatic experiences. Because the truth is that for every child that they remove from the love and care of their family, that child now has an 80% likelihood of going to prison himself. This system knows it. This system is creating the very objects that they go out and fight against every day in order to proliferate and profit off the illegal acts that they do. They know this. So the trauma that they create in the children that they rob from their families and the love that they need to be able to heal and grow and become a contributor to society and a member of society, that trauma results in an individual that has an 80% likelihood of going to prison. And we've got to stop this. We cannot permit this any longer. So we need these children to be protected. We need them to be back with their families. We need to get them home. But also you need to remember that every single prisoner is someone's child. Every single one of them was a child that was hurt, that has never been healed, and we look at them as a monster. So what I like to say, and certainly part of my argument is, we have got to stop looking at what people do. Because when we look at what they do, all that we see is a monster that needs to pay for things they've done. And that creates this vengeance-based system that we have in place today. But when we look at what's done to them, long before that crime, as a child, as a husband, as a mother, then we see that something tragic happened to them, and it wasn't their fault. And we could see the reasons why they've done the things they've done, because it changed the trajectory of their life. And now we want to heal them. Now we want to help them, because that creates the forgiveness-based system, the system that heals. Today, we're under a system because we're told to look at these people as monsters. But what we don't recognize is that that monster was created. It was created by the oppressive and illegal acts of this institution right here behind me. And we need to heal those brothers and sisters, because if we can give them the love that they lost in their childhood, in their whatever it was, as a result of a divorce or whatever it might be, if we can heal that trauma, there won't be crime anymore. And there won't be a need for prisons anymore. Because the reason why people hurt other people is because they themselves are hurting. If we can deal with the hurt of our brothers and sisters and get them out of these institutions that's continuing to hurt them even more and enslaving them, so that these assholes behind me can make billions of dollars every single year, and they're forced involuntary servitude of the weakest, most vulnerable in our society, if we can do that, we can overcome this issue. We can overcome the criminalization that exists here in America, and we can actually have a nation of peace, harmony, and love, as we were designed to be from the very beginning, when these people, 243 years, decided that they weren't going to follow the will of the people and instead proliferate this institution that they call prisons, but we call sweatshops. Thank you so much. Thank you.
Thank you for that answer, brother. And I pray that your response resonate with Griselli, and it helps her with her next step of what she should do. We have another question from Bridget.
Let's just do one more, because it's starting to get dark. I don't know if you guys can still see me anymore, but let's do one more. Yeah. Thank you.
Okay. Let's do this question from Bridget. Bridget asks, what I do now, since I have a under seal case with SCOTUS.
With SCOTUS. Oh, with SCOTUS.
Yes.
You have an under seal case? What do you mean? That the case is sealed here at SCOTUS? Is this Bridget? I don't see which Bridget is. Is this Bridget out of Ohio, out of Cincinnati? Bridget,
I'm not
say
sure.
yes.
Bridget,
Say yes,
no.
Bridget. Okay. Oh, different Bridget. Okay. So I don't really necessarily understand the question. I'm sorry, Bridget. I'm going to assume that you filed to SCOTUS here, and that SCOTUS has refused to docket it, and it's now. And they have just refused to hear it. Is that correct? That they use their discretion abusively to refuse to hear the case? Is that the question?
Let me see. Let me get to it. No. It did not tell me what to do. Okay. Let me see. They accepted under seal, is what she said. It's private.
Well, so nothing that our court system should do is private. Nothing. I don't care what anybody says. The courts should never ever operate under secrecy, ever, right? And so if they say that it's under seal, when you deal with the Freedom of Information Act, there's only two reasons why information cannot be released. We see these breached every single day, you guys. I'm saying that this is the way it's supposed to be. I'm not saying that this is the way it is. I'm simply trying to tell you this is the way it's supposed to be. So there's only two reasons why information cannot be released to the public. One is under executive order, right? Because it has national security implications. Or two, it would be detrimental to the health and well-being of the United States of America. That would be intelligence level. So only intelligence level or executive level has the authority to prevent you from being able to access the information that you need from the public officials. Doesn't matter whether it's their emails, doesn't matter whether it's the police reports, you are entitled to it. And when they refuse to give it to you, they're breaking the law. Once again, they are obstructing the administration of justice. Because how can you build a robust defense to anything when they refuse to give you the evidence that you need to build your robust case, right? We got to understand that the rules of evidentiary procedure is very clear. You cannot prevent evidence from coming forward. The judge is not there to determine what evidence should be admissible or not admissible. That's up to the attorneys to make that decision. That's up to the individual, because that judge has no idea whether it's admissible or not, because he's not even supposed to know anything about the goddamn case. So when a judge says, "Oh, I'm not going to admit that evidence," well, how would you know whether this evidence is admissible or not? Judge, you're not even supposed to know the case. That would be illegal. That would be obstruction of justice. That would be tampering with evidence, because every piece of evidence must be presented freely, fully, and truthfully to any matter pending before the court. So we cannot continue to operate in secrecy such as we do today, because when you operate in secrecy, the only reason why people want things to be secret is because they're not telling the truth, right? And if you're not telling the truth, then you shouldn't be in a public position, because that makes you a criminal, and we don't need criminals leading us anymore. So if you want to be a leader and lead our people, then lead us in a lawful direction. But that means that you're going to have free and open communication. That means that you're going to be truthful in the things that you do, because if you're going to continue to operate in secrecy, if you're going to build walls around your institution, right, and prevent people from having access to it, and you're going to prevent the media from being able to be fully aware of the situation, such as we were down in Guantanamo Bay and we are every single day here in America, right? When you're going to allow people to be murdered and then steal their heart from them and ship the body back to the family without the heart, we kind of need to know about these things, right? You're not going to operate in secrecy anymore, government, because when you do, we're fully aware of what you're doing. And you're criminals, because only criminals want to operate in secrecy. Only criminals don't want to be transparent. So if you want to be a leader and lead us, then you're going to operate in a lawful manner, and you're going to do it in full visibility of everything that you're producing, because otherwise we're not going to believe what you produce. So Bridget, at the end of the day, SCOTUS can't seal their records, right? That they are not intelligence, nor are they executive. Those are the only two reasons why freedom of information, why information cannot be released to the public. That's the only reason. Not judicial declaration. The judicial branch doesn't have the authority to be able to prevent information from coming forward. The only two ways is executive order and detrimental to the health and well-being of the United States. Everything else is supposed to be released. We need to push back on the system of government here and make them actually live up to their obligations.
Yes, she says that it has to do with equity jurisdiction. She says that her rights are protected under trust law. So that I'm assuming it's surrounded by. Okay, so
yeah.
What's next if the lawyer already got paid in full and finally gave you the evidence on court day? That was from 345 a lot. I hope I said that right. Forgive me if I didn't.
So what these attorneys are doing is they don't want anything to change. You have to understand that the corpus juris volume 2, corpus juris secundum volume 2, that creates the obligations of attorneys. This is their manual, their booklet. They are administrative officers of the court. We know that they're administrative officers of the court. That's their role. Is that so? They work for the Attorney General. They're there to protect the judicial machinery. They're not there for you and your best interest. So that's why they don't present a robust argument, is because every single case has a predetermined outcome, right? It's all predetermined. And you have to understand that this is a debt-based system that we have in place today. It's a debt-based system because if you choose to violate the law, you incur a debt that is owed to society, to which you're charged and called to account. So this is an enslavement-based system, the foundation of slavery, because it's a debt-based system. It's an economic-based system, and we need to be aware of that. We need to understand that. So when the attorneys recognize the fact that the individual that owes the debt is the slave, why would you defend the slave when they're not the ones that are going to be reaping the benefit of the money, right? The debt is not coming. The slave is not going to have any more money because the debt that the slave owes is now going to go to the other side. So the attorneys are always going to be on the opposite side. They don't want to represent the one that's enslaved. They want to represent the slave owner because that's where the money's at. So these defense attorneys they're not going to defend you. They're not going to put up a robust defense because why would they? They want to build this institution. They've done it. Like, this is their business, and they built this business based upon the enslavement of our brothers and sisters, the enslavement of the weakest, most vulnerable in our society. They've done it based upon ignorance, because they don't want to do what's necessary to actually fix this problem, because in doing so, their lives would change, right? It would be more competitive. They wouldn't be able to make $50,000 by you still saying that you're pleading guilty and still going to prison, only you're going to prison for 20 years instead of 30 years, right? I mean, there's the performance criteria of these attorneys is nothing, right? They'll charge you $20,000, take you to the day of trial, and then say, oh, I'm not going to represent you anymore, and walk away. I used to own an engineering firm, right? And when I had my engineering firm, I had to have billable criteria. I had to have certain performance criteria. I had to have certain products that were produced based upon the money that I spent. If my client, the Port of Seattle, gave me $20,000, I have to have and be able to show $20,000 worth of product that was delivered to them, right? I couldn't just say, well, here's a bill for $1,000, because I had to say, here, this is what we did for this $1,000. Here's my itemized description of the work performed. How many of you are seeking itemized performance criteria of your attorneys? If they say to you that they need $10,000, great. That $10,000, you have the right to be able to say, show me what you did for $10,000, because that's my product, not yours, attorney. And if you can't show me what you did for $10,000, then that's fraud. It's fraud, what they committed. So, if $10,000 is going to get you 2 phone calls, right, and that's it, well, what was the billable rate, attorney, right? You're going to charge me $5,000 an hour because you made 2 phone calls. The first phone call the day that I called you to take it on, and the next day you called the prosecutor an hour before we met in the courtroom when you talked me into pleading guilty. That's all they did. So where's the performance criteria? Where's the itemized list of the performance criteria? You have the right to ask for that, and they have an obligation to present that. And if they can't show you the product that they produced, it's not just a bunch of money that's theirs. Just because you give them $10,000 doesn't mean, no, these are professional services, and as professional services, they must perform professional services. They have a billable rate. If their billable rate is $250 an hour, it is what it is. If it's $100 an hour, it is what it is. But it's not $5,000 an hour. I can guarantee you that, right? Because their billable rate must be acceptable across the nation. So if there's no product that's being produced, that was fraud. It was overbilling. And the moment they put a stamp on an envelope to send to you, now it's wire. Now it's postal fraud, right? And the moment they called you up and said, hey, you have to pay, now it's wire fraud, right? They have to have performance criteria, and you have the right to be able to ask for it because they are providing a professional service. And as a professional service provider, that money that you give to them, it's not just their money. They can't just do whatever the hell they want to do with it. They need to have performance criteria, and you have the right to ask for that. You absolutely do. As a professional service provider, I can tell you that if I didn't have a product that I was delivering to my client, and I billed them for something that I didn't do, I was subject to going to prison. And so every single hour that I billed to any one of my clients, there was a product that came from that. And I had to justify that to my clients. And those attorneys have to do that to you too. Thank you guys so much.
Thank you, brother. Thank you.
Yeah, thank
So
you.
one last question from Willie B. He's been here while, and he's been asking this question. So I wanna make sure Willie B get an answer to his question. He's asking, what about going to jail for child support?
Huh. Okay, so two big issues here, Willie. First off, can you guys still hear me? I just pushed the button and it dinged. Can you still hear me? Give me a thumbs up if you can hear me.
Yep, we can hear you. We
Okay,
can
all
hear
right,
you.
good. Okay. So Willie, there's a couple of problems here. First off, who's accusing you of committing a crime? Who? Is it CPS, right? CPS. CPS is accusing you of committing a crime. You can't go to jail without committing a crime, right? Because that's a criminal sanction. So who's accusing you of committing a crime? The judge and CPS. Who do they work for? The state, right? Article 3, in all case which a state shall be party, the Supreme Court shall have original jurisdiction. The state doesn't have authority to send you to jail or prison or anywhere else because the state is a party in that cause. Who is the accuser? CPS. Who is CPS? They're an agent of the state. How do we know that they're an agent of the state? Because they're enforcing the laws of the state. Therefore, they fall under the executive branch because they are enforcing the laws of the state. The state created a law that said that you must pay child support, and as a result, they hired agents to work for them to go and collect this money from you, and that means that they're agents of the state. And as an agent of the state, again, when an agent of a state brings an accusation against you, right, then that same body of men, the state, cannot be the judge over you. The judge has no authority to oversee the disposition of that dispute because an agent from the very same body of men is bringing an accusation of a violation of a state law. So when a state creates a law and then they attempt to enforce it through one of their agents, that state cannot oversee the disposition of that dispute because the judge has a conflict of interest. He works for the plaintiff. So again, don't defend yourself anymore, Willie. You have nothing to defend yourself against. Don't create a conflict. Don't permit them to create the conflict because there is no conflict. State, you don't even have the authority to call me in. You don't have the authority to summons me into this courtroom because you don't have the authority to be able to oversee this case. And guess what, Judge? If you choose to proceed in this case after me informing you of this, Hill versus United States, you might want to go out and read it, Judge. Hill versus United States says that anytime a judge acts without jurisdiction, he is warring against the Constitution and committing the crime of treason. And guess what, Judge? There's two requirements of treason. One is it must be done in open court according to the Constitution. And you, sir, will be committing this in open court, which meets the criteria of treason directly out of the United States Constitution. And two, you can't say you didn't know that it was treason because I've now informed you of your jurisdictional obligation, the obligation from the Constitution that says that you don't have the authority to oversee this. Therefore, if you choose to proceed, Judge, you are now knowingly and willingly engaging in the crime of treason, and you can't even say I didn't know it. Now your mens rea exists, Judge, because I informed you of your obligation, and if you choose to proceed despite awareness of that obligation, well, you're putting that noose around your own neck. Your own, okay? Thank you guys so much. It's getting dark, and my feet are starting to hurt now, so I'm going to go, but thank you guys so much. I want to say, listen, continue to share. We need this stuff to move quite a little bit faster. There's a lot of information that's coming out. You guys, one of the reasons why this information is coming out at such a massive and quick rate right now is because I worked for them for many years. I came from the other side. I know their secrets. I know their deceit. I know their weaknesses. I know everything about this institution. I can do what I'm doing, but I needed to build this case. I needed to do it with my head down. I needed to be as safe as possible because if I would have been out there the last 9 years when I was building this case against these states, if I would have been out there popping all of this off and explaining all their secrets and telling them everything I knew, then I would have been at risk, right? I would have been a threat to them, and they probably would not have allowed me to do the things I was doing. But I built this case, and I did it quietly, silently, behind the scenes, without much attention. But now is the time where this has to get attention because we have a very limited amount of time. I'm not going to be in a safe position for very long. We've already had a couple attempts on my life. And so the thing is that this has to come out quick. I have a lot of information. I know a lot. If you guys went through my videos, you watch my videos, there is a ton of knowledge that you guys can get from there. You guys, it doesn't matter what your situation is. these videos will provide you with the information you need to overcome your particular situation. I'm trying to put this out. That's why it's coming out at a fire hose rate, right? Is because I had a lot of information that I was keeping silent for a long time, and now that information needs to come out, and needs to come out very quickly in order to keep me in a safe position so that I can make it to this court and I can argue on behalf of people in the United States for the deprivation of rights and freedoms that have been deprived of them by this country, by this government. So I'm here in Washington, D.C. I'm here for all of you. This argument, I'm going to, as long as I make it to this court alive, then I'm going to be arguing on behalf of people in the United States for the deprivation of rights and freedoms that have been caused by this particular government on all of your behalf. We're going to get your freedoms and your rights back. One last thing is I don't do this for money. Don't do it for money. I'm not asking for money, but I don't enter into any contracts. I don't accept paychecks. The 9 years that I've been building this case, I have never accepted a single contract. I only operate on donations, and we're in a situation now where we're down to our last $6, and I'm hoping that that we'll have some food. If not, it's okay. We're paid up until Monday morning on our room here in Washington, D.C. Monday morning, but after that, we don't have any more room. So if you guys are willing to help out, if you guys have the ability, don't take anything away from your family. But if you guys feel like you'd like to help out, help make sure that this mission is complete. We would welcome everything. We don't need very much money. It's $31 a day is what we pay for what we pay for a room, and then above and beyond that, it's whatever we can afford for food. But we have no vehicles, nothing. So it doesn't cost a whole lot, but if you guys would like to help out, if you guys would like to donate, we would love the blessing. I would very, very appreciate it because, again, we're down to our last $6. We have Cash App, we have Chime, we have Venmo, we have PayPal. They're all exactly the same. It is We Shall Be Free. That's WESHALLBEFREE. We shall be free. And guys, I love all of you. I'm very proud to be a part of this journey. And thank you guys so much for your support. Continue to follow here very, very soon. We're going to walk in these doors behind me here, and we're going to argue. And at that point, we shall be free. Thank you guys so much. God bless. Thank you so much, Dakota.
You're welcome to come out. You're all welcome to come out when that day comes. We all must rally and get out there to Washington, D.C. to stand behind them and show unity.
Hey, guys, it's a lot closer than you might think. Go out and watch the video that I just did yesterday that describes the House of Cards, and you'll see just how close we actually are to overcoming this particular situation. We're extremely close, guys. So I love all of you. I appreciate all the support. We've got 70 million people that are in this particular litigation that we're going to be arguing. I'm very proud to be in this position to be able to argue this case on your behalf and bring about this amazing ending that God has for us here in the United States of America. So God bless all of you. Thank you again, and have a great night, everybody.
All right. All right. Good night. Good night. Thank you for your time, Tanoa. I love you, brother.
We'll be back on tomorrow night, guys. Every single night now, okay? Every night we'll be answering your questions, okay? Until this court behind me, until they do the right thing, steps up and calls me in because they can't stand the shame that we're going to bring upon them every single night by exposing their fraud and their collusion. And so thank you guys so much. God bless.
Amazing. Peace and love.
Thank you.